Assalamualaikum warahmatullahi wabarakatuh. Today we are going to present about the case review of Bashir Ahmad Maula, Sahul Hamid dan lain-lain versus Pendakwa Raya. Before I started the presentation, let me introduce myself. My name is Nur Azza Ayuni binti Arifin and my other partner is Nur Alia binti Akesha. To start the case, the defendant, which is Bashir Ahmad Maula, Sahul Hamid, and his wife, Nur Sheila binti Kanan, was accused of involving in stealing the money from the victim of air flight tragedy MH370 by using ATM cards and online banking. The victims of these cases are the Chinese nation citizen named Tian Junwei and Hu Pui Heng. The defendant was accused of using both of the victim debit cards and ATM card to withdraw some money from the victim account. This was allegedly done in 4 transactions at HSBC Amanah ATM at Ampang Point between 10:02 a.m. on May 50 and 11:28 p.m. on June 29 in 2050. As is the both of the appellants guilty plea, and the second one is whether the first appellant can appeal against his conviction, and the last issue that arises is whether the sentences imposed on both appellants is adequate.
Next is the judgment of the case. The judgment in this is the first appellant and second appellant commit 4 offences. First appellant is Ahmad Bashir Maula Sahul Hamid was charged with 4 counts, and the second appellant Nur Sheila binti Kanan was charged with 12 counts. The appellants have acted and made several applications to adjourn the trial proceeding. The court also found during the period of the case running and being tried in a session court, the appellant had hired and changed lawyer 4 times. Further, after making his guilty plea, the appellant had twice applied for adjournment for a period of 2 weeks on the same reason, which is to manage their children. Of all the action taken by the appellant, this court found that the action were merely to delay the process and proceeding of the trial. The appellant was completely guilty and irresponsible in performing his duties as a bank official. As a bank official, she is in no way entitled to make any transaction against their customer account. In examining the appeal submitted by the first appellant, it was found through the fact of the case and the record of the court proceeding. At the time, the session judge has not yet passed any form of the sentence on the 2 appellants. The session judge had given opportunity to the appellants to think, and the convicts had already been recorded after taking into account that the appellants had voluntarily pleaded guilty and were represented by YBG case counsel at the time.